This is Barry Zelma speaking for Zelma on Insurance on YouTube. I am an attorney who has retired from the practice of law and spend my time now as an insurance claims consultant, insurance claims expert witness, author and creator of some of these videos. Today I'm going to read and tell a story from my book Heads I Win, Tails You Lose, which is available on Amazon.com as both a Kindle book and a paperback. This case is the case of the art Flambe. When a person decides to perpetrate an insurance fraud, he pushes the pause button on his morality. His plan to commit the fraud will then become so flamboyant and creative that even the most innocent of claims adjusters will detect the crime. Such was the case of a Belgian immigrant. He came to the United States shortly after World War II. He eked out a living with various jobs as a low-paid engineering draftsman. Before he decided to change his career and try arson for profit, he had led a dull but exemplary life. He, at the age of 60, married his second wife. Later, they actually had a child, and when the child was 3, he contracted phlebitis and underwent several surgeries. He was unable to keep up with his work, and in any event, the aerospace industry had just lost several major contracts. He lost his job. Unemployment compensation did not pay enough for him to make the $1,400 a month payments on his small 3-bedroom house in Cerritos, California. His lender, without a choice, foreclosed. After the foreclosure sale had occurred, he was still living in the house. His homeowner's policy was still in effect. He no longer had an interest in the house and was subject to eviction. The insured recruited his 16-year-old son from his first marriage to set fire to the house. He made certain that the wife and young daughter were away visiting relatives in Victorville. The house, with the assistance of much gasoline, burned to the foundation. Much to his surprise, because, of course, he was a draftsman, not an insurance scholar. The insurance company immediately denied his claim for loss of his structure. He did not know that he must, at the time of the fire, have an interest in the structure to collect indemnity. The mortgagee, now the owner, received full payment. He had $100,000 in contents coverage and needed to collect it all. Of course, because of his extended illness and lack of income, the house had relatively threadbare and simple furniture and furnishings. He needed to bring the values up somehow to effect a policy limits payment. He prepared an inventory of all of his household furniture and furnishings and added to that an original oil painting by Rembrandt, an original oil painting by Pablo Picasso, and an original oil painting by Vincent van Gogh, which he of course pronounced correctly as Vincent van Gogh. The adjuster was surprised that anyone who owned such valuable artwork had difficulty making a $1,400 a month payment to his mortgage company. The adjuster could not understand how the insured could allow his house to go by foreclosure. So, of course, the adjuster retained counsel to examine the insured under oath. Under oath, the insured's testimony established that the insured had attempted to perpetrate a fraud on his insurer. The insured testified he was of royal birth, his father being a baron in Belgium. The baron lived in a castle outside of Antwerp, having earned his fortune in the diamond trade. The baron, pleased to learn that he had become a grandfather again, brought his son, daughter-in-law, and new granddaughter to visit him at the castle. They spent a month at the castle enjoying the generosity of the Baron. Before the insured left, the Baron pointed to 3 oil paintings on the castle wall and told his son to take them home. Grandfather the Baron made the paintings a gift in honor of the birth of the new granddaughter. The insured testified that he took the oils out of their frames, rolled them up, and placed the 3 in a shipping tube, which he hand-carried back to the United States. Since they were gifts, he did not report them to U.S. Customs. He had no written record of his ownership or possession of the paintings. He described the Rembrandt as the dark painting of people sitting around a table with a bright point of light. When asked to describe the painting by Van Gogh, the insured testified, quote, "Another Dutchman. The painting was in the same style," close quote. Of course, counsel knew that although Rembrandt painted in very dark colors, Van Gogh, however, painted in wild, bright, and exuberant color schemes. A dark and brooding painting like that of a Rembrandt never came off Van Gogh's brush. Further, counsel knew, after consulting with an art expert, that Rembrandt painted most of his works on board, planks of wood. It was therefore impossible to roll it up and put it in a tube. If the insured, in fact, had one of Rembrandt's rare canvases and had rolled it up when he arrived home in Cerritos, he would have found a clean canvas and a pile of paint chips at the bottom of the tube. The varnish used on oil paintings would have just cracked up and fallen away. The insured tried to help the insurer's investigation by providing evidence. He gave the adjuster and the lawyer at the examination under oath a photograph of a family dinner where the Rembrandt was supposed to be visible in the background. The insured identified the photograph as depicting the original Rembrandt oil painting in its background. Counsel for the insurer had the photograph enhanced and enlarged. The enlargement showed the single bright point of light described by the insured that was cast, however, on the painting of an electric light bulb. Of course, Thomas Edison had not been born when Rembrandt was painting, and would not be born for at least 300 more years, to the surprise of the insured only. The insurer rejected the claim presented by the insured for fraud, false swearing, and material misrepresentation of fact. Unable to accept the decision of his insurer, with nothing to lose, the insured found a young lawyer who was willing to take on his case and sue an insurance company because of the experience that insurance companies will often settle even if they owe nothing. Suit was filed for breach of contract and breach of the covenant of good faith and fair dealing. Although the fraud was obvious and blatant, the cost of defense of the bad faith action mounted. The suit dragged on for 3 years. Trial counsel for the insurer were unable to convince a court to grant summary judgment, and the case would need to go to trial before a jury. Finally, at a mandatory settlement conference, the lawsuit settled for a payment by the insurer of $30,000 against the advice of defense counsel, who, regardless, admitted he would charge more than $30,000 to take the case through trial and a possible appeal. There is no question the settlement was an appropriate economic decision if the insurer was only considering the single lawsuit. They were dealing with a plaintiff's lawyer they saw on a regular basis. To pay him tribute as an economic decision was illogical. when a plaintiff's bad faith lawyer is paid $30,000 by an insurer for a lawsuit that any 3-year-old would know was a blatant fraud, he has been given an invitation to file more suits against that insurer regardless of the merits. Paying a blatant fraud is tantamount to providing plaintiff's counsel with the key to the vault that holds the assets of the insurance company. The insurer that does so fools itself, only that it is making a reasonable economic decision. It will pay, in the future, thousands if not millions of dollars, because the plaintiff's bar knows that that insurer will pay off rather than pay their lawyers to defend the most spurious of suits. Insurance fraud is a crime. It is a crime that is seldom prosecuted, and although this fraud was reported to the appropriate agencies, nothing was done to investigate the crime. It just didn't seem worth the effort to a prosecutor since no one was hurt in the fire. This story sits in my book, Heads I Win, Tails You Lose, and is available along with more than 80 other stories of insurance fraud that either succeeded or that were defeated. And you can find them at Amazon.com by just seeking publications in my name or by the name Heads I Win, Tails You Lose. Or you can find them at my website, www.zalma.com, where if you link on the Insurance Claims Library, you will find links to this and various other books I have published on the topic of insurance and insurance fraud.